This is originating application 192 to 196 of 2023, summonses 3876 to 3880 of 2023, Babel Holding Limited and other matters.
All right, good evening, Mr. Alexander Yeo, Ms. Sherilyn Lee, and Mr. Richard Xu for the applicants, correct?
Yes, Your Honor. May I also have permission for a practice trainee of the firm and an intern to sit in?
Certainly, thank you.
My apologies, and for my instructing counsel from Latham and Watkins.
All right, certainly, thank you.
Thank you.
And for the non-parties, Parastate Labs, Mr. Fu and Mr. Tan, correct?
Well, that's right, Your Honor. So my name is Mr. Fu Jihao, and my colleague with me is Mr. Mark Tan.
All right, thank you. For Mr. Yang Cho, Mr. Michael Chan, correct?
Yes, Your Honor.
All right, thank you. Genesis Global, Mr. Jonathan Tang and Ms. Charlene Wee.
Yes, Your Honor.
All right, thank you. All right. Any other attendees? All right, I think not. All right. Thank you. Let me Mr. Zoom allocution first. So parties reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, Mr. Yeo, thank you. I've received your submissions. Your application for extension of the moratoria. Let's begin then.
Thank you, Your Honor. Yes, this is an application for a moratorium extension. Your Honor has granted moratorium extensions for this matter before. What has changed in the latest application is that we have since held the scheme meeting, and approximately 80% in value, in number, representing 90% in value, have voted to approve the scheme. Your Honor will see on screen the percentages reflected in the applicant's joint written submissions. I do need to correct these figures slightly in light of a letter which we had just filed in court. And my apologies, my personal apologies for sending this so late. We had only just last night found this out ourselves, that the percentages had included certain related party creditors whose vote, as Your Honor knows better than I, may need to be wholly discounted. So the letter addresses what the revised percentages are if the votes of related party creditors are excluded. And I will jump in the letter straight to paragraph 4, subpara 3. That we listed in paragraph 4, subpara 2, 6 possible related party creditors, and we set out what their relationship is, that they are either employees or former employees or shareholders holding less than 5%. We highlight 2 creditors in particular who have either personal or familial relations with Mr. Yang Zhou, who is the director of BHL, and who has been filing all the affidavits, or most of the affidavits to date on behalf of the applicants. That is serial number 2 and serial number 5. So, Your Honor, I will jump straight to paragraph 4, subpara 4 of the letter, where if you exclude those 2 out of the 6, the percentages still show 79.55% in number for the scheme and 90.11% for the scheme in value. Now, just to assist the court, if we wanted to exclude all of the possible related party creditors, that is paragraph 4, subpara 5. And you can see that we still have 80% for in number, 92% for in value. If we exclude the votes of possible related party creditors, that's because some of the related party creditors in fact voted against the scheme. And in any event, we also set out the worst case scenario, which is if we had discounted all of the related party or potential related party votes in favor of the scheme, but included the vote of the possible related party creditor who voted against the scheme. And Your Honor will see that we still pass by, in my view, an overwhelming majority.
All right.
Your Honor, there are 1 or 2 other items of full and frank disclosure that we want to bring to Your Honor's attention. I will jump in my submissions to paragraph 18, subpara 6.
All right.
We stated in this paragraph that we are preparing to file the sanction application. That sanction application has since been filed yesterday night. This is slightly later than the original indicative timetable that we had previously provided to the court. In that indicative timetable, we had indicated that the sanction application would be filed by the 31st of December 2023. But in the affidavits, we have explained why there was a delay. Essentially, to give full disclosure, there were delays in the applicant paying certain legal fees, and also certain complications and delays due to Parastate's appeal, which has since been withdrawn.
Mm-hmm.
A further item of full and frank disclosure is paragraph 19, and I intend to spend a little bit of time on this because it is something that may be important to Your Honor.
Mm-hmm.
Paragraph 19, subpara 2, says that the chairperson, which is Deloitte, or from Deloitte, the chairperson is from Deloitte, inadvertently left out or omitted to circulate a list of creditors who filed a proof of debt to every creditor who had filed proofs of debt within 7 days after the proof of debt submission deadline. That is required under Regulation 3 of the Proof of Debt Regulations. Your Honor, we submit that this inadvertent omission is partially remedied, not fully, by the fact that the scheme managers had, first of all, circulated this list of creditors very recently. But even before that, in the same submissions, we also set out that we did publish adjudication results, albeit 23 days later, 23 days after the timeline required under Regulation 3. Now, this adjudication result would listed, in fact did list, all of the names of creditors and all of the claim amounts and adjudication amounts. So we submit that partially mitigates the original omission. At subpara 3 on the same page that is flashed on screen, Your Honor, I would highlight, however, that the adjudication result does not contain the address of each creditor and a brief description of the nature of claim, which is required for list of creditors, but that has been remedied, albeit yesterday, Your Honor.
So what happened yesterday?
We filed the list of creditors, albeit late. Your Honor, the same omission for the original list of creditors was repeated again because an updated list of creditors was supposed to be sent under Regulation 7 of the POD regulations. So same thing, this was again remedied by a revised adjudication result, which lists all the creditors and the revised adjudicated claim amounts after the independent assessor had done their work. To review any appeals. So, Your Honor, on behalf of the applicants, we do apologize for this inadvertent omission made by the chairperson from Deloitte, not necessarily by the applicants, but we hope that no prejudice has been caused thereby. The next update, Your Honor, is set out at paragraph 20 of the submissions. Which Your Honor will see on screen now, that as Your Honor is aware, Parastate had filed an appeal to the Court of Appeal against Your Honor's convening order. Long story short, Your Honor, that appeal has since been withdrawn. Importantly, Parastate's concern, as expressed in the appeal papers, was that there was a lack of proper financial disclosure, and we had expressly circulated Parastate's concern to all creditors as part of the appeal papers. But importantly, they withdrew their appeal after we filed the supplemental explanatory statement where we gave, in our view, the relevant disclosures anyway. So hopefully that matter has been addressed. The last two bits of full and frank disclosure that I would like to give Your Honor, the first is at paragraph 29, which relates to the timing of this application for a moratorium extension. Registrar's Circular number 1 requires that we file this 2 weeks in advance. By my calculation, Your Honor, 2 weeks in advance of the expiry of the moratorium would have been by the 24th of December. We instead filed this application by the 27th. The applicants do apologize for the delay, but we've also explained why the delay of 3 days. If for nothing else, yes, there was a cash drain, there were delays and complications due to the Parastate appeal, but also, Your Honor, just the festive season did cause some delay there. The last bit of full and frank disclosure that I would like to give Your Honor is actually contained in the sanction affidavit that we filed. I will not bring Your Honor to the relevant page, but let me just disclose what the issue is. I will give Your Honor the precise citation, which is the 10th affidavit of Yang Zhou, dated yesterday, at paragraph 48, subpara 5, which essentially is that while we believe this is not relevant given Your Honor's holding on the deed poll structure and the single class structure of the present scheme, if we had taken Babel Asia's asset management's creditors' figures in isolation, the scheme would not have passed. This goes to Parastate's argument that they should be in a separate class, or Babel Asia Asset Management should not be consolidated with all the other creditors via the deed poll structure and the single class structure of the present scheme. They've said that they should be a separate class. But Your Honor, I would submit that that is not relevant in light of Your Honor's previous holdings that the deed poll structure is indeed appropriate, and the single class structure of the present scheme is also appropriate.
All right. Right. So in terms of what you're asking for today, Mr. Yo?
We're asking for an extension of the moratorium up until 3 weeks after the sanction application is finally determined.
All right. Because?
Because, Your Honor, I think there has been the scheme meeting. We have met the deadline for holding the scheme meeting, and the scheme meeting has passed by an overwhelming majority. Your Honor knows better than I the Skaugen test for moratoriums and thereby moratorium extensions, that there be a reasonable prospect of the restructuring passing, there be evidence of creditor support, and that this application be bona fide. I submit that all 3 factors in the round are addressed by our submissions, but most importantly by the fact that the scheme meeting passed by an overwhelming majority. And all we're asking for, Your Honor, is a moratorium extension to allow us to still be covered up until the sanction application is determined, and the consequent steps after that to register, to lodge the sanction, the sanction order.
All right. So what are the timelines that you're looking at?
We set out the timelines at paragraph 26 of our submissions. We have already gone past most of these timelines. I will just highlight a couple. So if we stay on screen right here, Your Honor would have seen that the previous proposal was for the scheme meeting to be held by the 17th of December. That has been done. The next timeline after that was a court application for sanction. That was supposed to be the 31st of December. We filed by the 4th of January. So just a few days late, but we've hopefully explained why. We are looking to ask the court, if possible, to have the court hearing to approve the scheme by the end of January. But we did indicate to all creditors that that is subject to court availability. And then the scheme effective dates would be the date on which the sanction order is lodged with ACRA, which is why we've buffered a little bit. To be very honest, we've buffered 3 weeks after the sanction order, just in case of any complications.
What's the current expiry of your moratorium?
7th January.
I don't like to give extension dates that float in this way. I'd rather give a specific date. Mr. Yeo, what would you suggest?
Your Honor, then happy to take a specific date, but that requires a little bit of coordination with Your Honor's schedule, if I may permit.
Give me a target date.
Certainly. Could we have the hearing of the
No,
section
just give me a target date of when you think the sanction date should be at the maximum.
at the maximum? Your Honor, I would suggest early or mid-February. That gives more than enough time for the sanction application to be heard, and includes maybe a week or two worth of buffer. So if I just look at the calendar, today is the 5th. If sanction could be heard by either the 2nd or 9th of February, then the moratorium could be extended to perhaps 3 weeks after that, if possible, Your Honor.
Then what is that date then?
So if I just take the 9th of February, which was the latter date that I had indicated to Your Honor, and I take 3 weeks from then, that brings us to the 1st of March.
The 1st of March has a long stop date. All right. Anything else, Mr. Yeo?
Nothing else from me, Your Honor. Thank you very much.
Thank you. All right, sorry, Mr. Fu, anything?
Nothing for us, Your Honor.
Thank you. Mr. Chan?
Nothing from us as well, Your Honor.
Genesis Global, Mr. Tang?
Nothing from us, Your Honor. We take no position in the application.
No position. All right, thank you.
Your Honor, if I just may add that following the other creditors' council's confirmations, there appear to be no creditors who are objecting, and we have not received any other objections either.
All right, I'll grant the extension as sought to the long stop date of 1st March 2024, but hopefully we'll be able to have a sanction date earlier. So moratorium extension extended as sought. Sorry, let me have one of the summons numbers, please, Mr. Yeo.
Yes, Your Honor. Just give me one moment. Sorry.
6. All right. All right, using 3876 as the model, and I assume they're all in the same form. So order, well, prayer 1A granted to 1st March 2024. So I'll leave you to amend the language, Mr. Yeo. All right.
Yes, Your Honor. That makes sense.
Prayer 1B is also granted. Sorry, and 1C. 1B and 1C.
Thank you, Your Honor.
Anything else, Mr. Yeo?
Nothing else from us. Thank you, Your Honor.
Anything else from any of the other parties? If not, right, thank you then. And Happy New Year to all of you.
Happy New Year.
All right. Court is
Hey,
adjourned.
Your Honor.
Good day.
Good day, Your Honor.